Okay, well, good afternoon, everybody. So, my name is Craig Hodge, and I'm pleased to welcome you to the Heritage Conservation Proposed Legislation Changes. It's the workshop, and glad to see so many of you here. I'm a councillor with the City of Coquitlam. I serve as Metro Vancouver's representative on the UBCM executive. I also chair the Community Safety Committee, and I'm a member of the that's I can change my script here. I'm also on the I'm on the Community Safety Committee as well. So I wear a number of hats here, but I'm pleased today to be your moderator of this. I'd like to begin by acknowledging that we're fortunate to be able to gather on the homelands of the Songhees and Coquitlam people. We respect and commit to deep consideration of their history, culture, stewardship, and voice, and we're grateful to have the opportunity to hold this session here today. The Ministry of Forests initially proposed a session on tools for permitting under the existing Heritage Conservation Act. However, as more information became available about the significant changes proposed for the Act, UBCM asked that the Ministry to change the focus of this session, and with a focus on the plan changes to the Heritage Conservation Act, including but not limited to the archaeological assessment. So we hope that this session provides local governments with an opportunity for an in-depth consideration and discussion. Attendees will be given direct feedback to the Ministry and Forests and potential impacts of these changes for local government development and permitting, infrastructure and capital projects, and management and use of the Crown and private lands. So now I'd like to introduce the presenters for today's session. First of all, I'm really pleased that that the Honourable Ravi Palmer, Minister of Forest, is able to join us today. So this is a recent addition to the program, and we appreciate him being here to open the session. He's going to have some opening remarks, and then we'll get into the previously scheduled program. And I just want to say that in addition to Minister, we're very pleased that for you being here, recognizing the interest in this topic, but also that I understand that you've already reached out to our incoming president just within hours of our new president, and I really appreciate that. I think it shows that your willingness to listen and engage in a dialogue, and this is something that UBCM we've been asking for. So I just want to straight at the top say thank you very much. We look forward to your comments and for the conversation here today. Also joining the Minister, we have Julian Russi, who is the Assistant Deputy Minister of Tenures and Economics Division. We have Jessica Ruskin, who is the Executive Director of Heritage Conservation Act, Transformation Project and Forest Landscape Planning Branch. I asked her if she can actually get that all onto a business card. That's a mouthful and a big portfolio that she's looking after, and I'd be interested to hear what Jessica has to say. And also Elizabeth Scambler, who is the Director of Policy and Legislation, Heritage Conservation Act Transformation Project. So and then after that, we will have time for questions after their presentations. So please, Mr. Minister, please join us and look for your remarks.
Hi, everyone. Good afternoon. Hope you all are doing well. It's great to be here on the territories of the Algonquin-speaking peoples, the Songhees and Esquimalt First Nations. I'm not going to try to be as active as I usually am with my voice. Like many of you who've been talking an awful lot this week, I've started to feel it, and so hot water has been my friend this afternoon. I'm going to be brief. You'll get an opportunity to hear from my colleagues about the work that we've been doing on the Heritage Conservation Act transformation over the course of the last number of years, but in particular, the work that is ahead. I want to thank you for attending today's session. I want to thank UBCM for its flexibility in allowing me to be able to come and talk about this important issue. I know many people often get a bit surprised thinking, what the hell is the Minister of Forests doing talking about archaeology? But very proud to have archaeology as part of my ministry. And boy, have I been doing a lot of listening and learning from the team on archaeology these past number of months. I want everyone to know in this room and all UBCM delegates to know how important it is to have your local voice and the voice of local governments reflected in the work that our government does I recognize that that is always a challenging balance for any government, but in particular, I know that it's been a message that has resonated in many conversations, not just pertaining to the Heritage Conservation Act, but other pieces of legislation, but also other discussions on important issues. I've got about 70 local government meetings. I got West Kelowna that I'll be running back to shortly, but I want you to know that we heard you loud and clear in terms of the Heritage Conservation Act. And that's why I announced yesterday that we'll be extending the engagement period to the middle of November as our ability to be able to ensure that our conversations are rooted on the ground and making sure that you have an opportunity, not just as local government leaders, but I also know that there are a lot of staff in the room that are doing the hard work, having an opportunity for you and your teams to be able to provide feedback as well. I can't tell you enough how thankful I am to have an incredible group of public servants who are supporting me in this work. Jillian, Jess, and Elizabeth have been working on this project for a very long time, and I know we're going to do an incredible job walking you through this presentation. But let me start here. The system we have right now is broken. The Heritage Conservation Act was written in another time for another reality, and while it has served its purpose in the past, today it leaves too many people frustrated. Families and communities held up by delays, First Nations shut out of decisions about their own ancestors, developers and local governments frustrated, mirrored in uncertainty, and heritage sites, the sacred, the historical, the irreplaceable, left unprotected until it's too late. This engagement about the speeding up of permitting under the Heritage Conservation Act, the proposed updates would reduce HCA permitting timelines even further without reducing consultation with First Nations. The intended outcome that I have in the future in bringing forward legislation is to enhance First Nations' role in decisions that affect their heritage and ensure permitting efficiency, process certainty, and transparency while promoting responsible stewardship. For all communities, this means protecting valued heritage and history, and for property owners, local governments, and businesses, this means more process certainty, fewer delays, fewer surprises, and faster decisions. And when building a home, rebuilding after a disaster, or starting a new project, this is really important. I had an opportunity to visit Lytton not too long ago and saw firsthand the devastating challenges that Mayor O'Connor and her community have gone through after a devastating wildfire in rebuilding. And it is important to bring this outdated legislation in line with the important work that we are doing every single day in our government and all the work that local governments are doing with Indigenous peoples by bringing the outdated legislation in line with the Declaration Act. Let me be very clear. The intended outcomes of modernizing the HCA will not automatically restrict more land from development, nor will it apply to shared decision-making on private property. I want to reinforce that to you. This is engagement, the work that we're doing. We've all been engaging with local governments, industry, and businesses to find solutions and ways to update and improve the Heritage Conservation Act, to make permitting faster and easier, to help communities rebuild quicker after disasters, to protect heritage sites more effectively, and strengthen the role of First Nations in decision-making about their own heritage and ancestors. We've heard many important things from many of the people in this room. I've had the opportunity this week to have a number of conversations with local governments throughout the province about the challenges they face with status quo, with the Heritage Conservation Act as it exists today. And I'm glad of all the feedback that we have received to date. More than 360 local government representatives who have participated in our engagement activities to date on this important project. And I've heard loud and clear over the course of UBCM that there needs to be more opportunity for engagement. I want to acknowledge and congratulate the new president. I'm looking forward to sitting down with her in the next couple of days to work together to ensure that it can be as robust and meaningful as possible. I learned from my mentor, John Horgan, that before one should act, they should be doing a lot of listening and learning. It's clear that I've got a lot of listening and learning to do on this file, and so I'm looking forward over the next number of weeks, not only getting the opportunity to sit down with many of you on one-on-one conversations, but also looking forward to extending that to First Nations, extending that to the business sector, and extending that to the real estate and development sector as well. At the end of the day, I think we want to ensure that we're fixing the status quo and building something better. I want to continue to hear from you today as part of this process and in the process ahead. My ministry will be reaching out to all local governments through UBCM in addition in the next number of days to lay out some engagement opportunities that I hope will be more meaningful and will provide local government leaders as well as staff an opportunity to provide your direct feedback, again, ensuring that we understand the challenges with the status quo and start having conversations on how we can solve these challenges. We've also, excuse me, we've also heard that for many of you, the ideas that you have pertaining to the Heritage Conservation Act has spoken to the confusion that exists with the current act. That's an issue we face not just in the Ministry of Forests, but all across government is legislation, and we're going to be working hard to ensure that we have websites as well as QAs to better reflect those challenges. I just had an opportunity to meet with the Mayor of Williams Lake, who's expressed his frustration as well as that of his staff in terms of a water main project that they've had where they've been delayed with permits, and we're looking forward to taking the feedback that he's provided in that meeting and additional feedback that'll be provided, and just want to encourage you to do the same as well. It's been clear that the Heritage Conservation Act, which was last updated 30 years ago, about the same time I was born, is failing to meet the needs of local governments, First Nations, and many others. And I want to just give you some examples. A family that purchased land to start an agritourism business at a site with a documented archaeological significance, but they weren't informed prior to purchase, leading to the project being halted after investments had already been made. Another example we hear is a couple purchased a vacant lot to build their dream home at a site with documented potential for archaeological sites and had to halt their plans when burial mounds were identified. These are only two examples of how the status quo is not working and why we are engaged in this process and what is so important that we get this done right. Some of what will be discussed is on the important work of how to preserve First Nations heritage in the best way possible. I think we all can agree in this room that if someone is digging on their property and comes across ancestral remains or cultural artifacts, it's not only the right thing to do to ensure steps are taken to mitigate impacts, it is the law under the HCA. Some of the proposals, we're looking at ways to ensure we minimize surprises like this to better protect these important sites and enable quicker permitting to mitigate impacts and get work done faster. And as you've learned through this engagement process, at the core of this is making sure we get these processes done right. When you imagine your home was damaged in a flood or fire, imagine that you were in Lytton as an example and you want to rebuild. Or maybe you're starting a new project like building a home or a community infrastructure project, or you're building a massive mine next to a community and you're doing everything right, but the process is slow, confusing, and expensive. That is what the Heritage Conservation Act is currently, and we're looking to change that. I want to be clear to everyone in this room that no decisions have been made to date. I want to hear from people impacted and affected so we can make sure that in the future legislation we will draft will meet the needs of all people in British Columbia in the best way. I also want you to know that beyond today's session, beyond the provincial government working with UBCM, I'm open to feedback on how best we can engage in a meaningful way, whether that is meeting directly one-on-one with local governments or hosting more follow-up workshops. And again, I'm looking forward to working with the new UBCM president in regards to that. At the end of the day, this is a very complicated piece of legislation, and I think anyone who's had an opportunity to work with the Heritage Conservation Act can speak to that. This is an important piece of legislation. It's important to First Nations people. It's important to the people in this room as local government leaders. It's important to those that are bringing forward resource projects. I spent some time in Ottawa a couple of weeks ago and talked about the need for a stronger response for our forest sector. At the same time, I heard about the opportunities that exist in our oil and gas sector and mining, LNG as an example. We have to move projects forward. I think we can strike that balance. It's a tricky balance, and I think often we get pointed into corners. It's just only responding to this issue or only responding to that issue. I'm working hard every day in my role as Minister of Forests on fiber supply challenges, but also as it relates to archaeology, to making sure that we strike that balance. I want to thank you for allowing me to take a few minutes of your time to be able to start off this conversation. I know you're going to be left in good hands with the incredible team up here. They're going to walk you through a presentation that really speaks to the challenges that exist today and some of the ideas they have. And I encourage you, whether in this conversation or in conversations that will exist after today, to really provide your feedback. My email, for.minister@gov.bc.ca. Encourage you to take advantage of it. I actually do look at my inbox quite frequently. It's not a healthy thing to do, but I encourage you to reach out, and I know a number of the mayors have my number here as well. Thank you again, and without further ado, I think I'll turn it back to you. And I'm sorry I have to run. Mayor of West Kelowna is not happy I'm missing his meeting. Thanks very much.
Thank you.
Yeah,
Thank you so much. Yeah. And again, thank you, and I appreciate you making time, because I know ministers are all busy and wanting to meet with our colleagues. So next, we're going to hear from Jillian Roussel, who's the Assistant Deputy Minister of Tenures and Economics Division.
Yeah, thanks so much. And I'm going to keep it short. I'm just going to explain a little bit about how we're going to walk through this. So we've got Jess and Elizabeth here. We're going to walk through a pretty detailed deck with folks. So for those of you that attended one of our sessions prior, some of this might be a duplication, but we just want to make sure that everybody in the room is starting from the same place in terms of the level of understanding about what the proposals on the table are. And again, like the minister said, these are just proposals. We want to hear your feedback. We've got a few questions that we're going to put up on the board at the end of the presentation when we open it up for Q&A. But we really are looking for feedback on how these proposals will impact your community, how will they help, which ones are potentially problematic. We have not started to draft the legislation, and there is a ton of room to influence this. So we're really looking forward to hearing your thoughts and comments today and in our other sessions that we've had and are having. So with that, I'll pass it over to Jess.
Good afternoon, everyone. Hopefully this works. Perfect. So as mentioned, my name's Jessica Ruskin. I'm the Executive Director responsible for the Heritage Conservation Act Transformation Project. I've had the privilege of being with this project since its inception in 2021. So very grateful to be here today in Phase 3 and getting feedback from local governments, from First Nations, and other interested parties on this important work. I really want to thank UBCM for the opportunity to be here and to continue the conversation. I understand I have before me this very powerful tool which will help us navigate through the slide deck, and that hopefully, there we go. There's some instructions here to participate in Slido. That is the venue to ask your questions. As Jillian mentioned, those will be taken throughout the presentation, and we'll have time at the end to go through those. So that's the QR code right there. Maybe linger on that for a second. Yes, thank you. Is that better? Perfect. Okay. Testing, 1, 2, 3. Okay. Thank you. All right, so I'm going to jump right in here. So as the minister mentioned, there's 4 key outcomes to this work. The first is around making permitting faster and easier. The second is helping communities rebuild quickly after disasters. The third is strengthening the role of First Nations in the management of their cultural heritage. And the fourth is protecting heritage more effectively. To meet these broad outcomes, there are over 50 policy proposals that we are looking for feedback on. And we're going to focus on a few of the key pieces today in the following areas: faster and easier permitting, rebuilding after disasters, due diligence and awareness, strengthening, again, First Nations' role in the management of their cultural heritage, protecting heritage more effectively, and an enhanced compliance and enforcement toolkit. All right, got this slide deck going. So just to recap, again, any of you who have been involved in previous sessions would have seen this slide and in any of the other materials that we have available on our website or previously distributed. So the HCA transformation project has been a multi-year, multi-phase project. The first phase focused on really identifying the priority areas for change. Again, what is the current problem with the HCA? How is that impacting people on the ground? And that was undertaken through broad engagement with First Nations, with local governments, and stakeholders. Phase 2 really focused on developing the policy intentions. Again, the proposed solutions to address those problems we heard in Phase 1. And again, that was undertaken through broad engagement with all of those parties. And following confirmation of the government in 2024, we reconfirmed the mandate that this work was a priority and it would continue. And what we're engaging on in Phase 3 is what we have direction to change. The primer, and I want to, is this on here? Oh, no.
It was on the previous one.
Okay, I'm going to go back to this for just a second here. So this QR code with the cute dinosaur in it links you to the policy session primer, and that goes through all of the 50-plus policy proposals in detail. For those who haven't received in their inbox already, you might want to take a picture of that, and then you can kind of follow along with the slide deck that we have today. I'll give that a couple more seconds. So phase 3, where we're at now, is really focused, again, on getting feedback on the proposed changes and implementation considerations. As the minister mentioned, we know that the HCA needs to work better for everyone, and we need your feedback to ensure that these proposed changes will accomplish just that. Legislation hasn't been drafted yet, as previously mentioned, and there is an opportunity to provide feedback to refine these changes. We've also created a local government survey to better understand how each local government is currently managing heritage considerations, and also created fillable feedback forms on all of these proposed changes. And again, that's to help to support, gather feedback to inform the next stages of this work. We'll have a QR code at the end of this presentation so that you can go ahead and fill those out as soon as you have time. I also wanted to mention that we've launched a public survey that was done towards the end of August, and that provides the opportunity for the general public to provide input onto this process. So please tap your neighbors, tap your contacts, and encourage them to fill out the survey. Some of the key questions that we've been asking through this phase of engagement include, how does this policy direction support your local community's interests? What are the unintended consequences of the proposed policy direction that we need to address in this phase? And what kinds of guidance, education, or outreach would be needed to support implementation? And again, we'll put those questions up towards the end of the slide, but wanted to kind of plant those right now as we go through the presentation to support some questions down the line. So before we launch into the policy proposals, we thought it would be valuable to briefly summarize what we've heard from local governments through engagement to date. So phase 1 engagement with external stakeholders and local governments, which took place in 2022, that included in-person sessions, we had online and virtual sessions, one-on-one meetings, and opportunities to provide feedback through written submissions or an online survey. Over 80 attendees representing 56 local governments participated in that phase. And what we heard from local governments was similar and had overlapping themes with other interested parties, be those archaeologists, developers, and industry. And we heard that consideration of heritage sites must be done earlier in project and land use planning processes, that we need tools and greater support for local governments to proactively manage heritage values, that there needs to be more consistent approaches and clear responsibilities for local governments. We know that many local governments are doing creative and proactive things to manage heritage in their local jurisdictions, but there isn't a standardized approach across the board. We also heard that there needs to be better education and guidance on the Heritage Conservation Act, a need to provide property owners with better access to information about heritage sites, and then we heard loud and clear that there are long permitting delays, concerns with the lack of archaeologists, and high costs, which have negative impacts on local governments and developers. And lastly, we heard loud and clear that local governments must be consulted on legislative changes. Phase 2 engagement, which took place in 2023, focused again on developing policy intentions and scope. And again, that was done through broad engagement with First Nations, local governments, and stakeholders. And in this phase, we had 89 local governments attend, representing 89 local government representatives representing 63 local governments. What we heard in this phase validated some of what we heard in phase 1. Local government participants were largely supportive of some of the changes that were proposed at that time, and which included support for enhancing decision-making agreements with nations and enhancing compliance and enforcement. We also heard about some gaps, again, that the proposals did not address permitting efficiencies and that we need better tools to address heritage during emergencies. And some messages were reiterated. Again, the need for clear roles and responsibilities and consistent approaches to the management of heritage resources. Ongoing concerns around the costs and impacts borne by local governments, individual property owners, and project developers, and a need to improve access to archaeological inventories and mapping tools and better means to raise awareness for developers. So let's look at what we heard during those 2 phases and how that has influenced and shaped the policy proposals we'll be talking with you about in greater detail today. So again, we heard that heritage needs to be considered earlier in the project, and land use planning processes and tools, and a need to create greater awareness for developers. So in response, we've added new due diligence measures to require local governments to see proof of an archaeological data check prior to issuing development and building permits, and to require data checks during the sale of property. And we know through conversations with many folks that many groups are doing this work already. In response to hearing that more tools were needed to support local governments to proactively manage heritage, we proposed enabling heritage management plans and heritage management zones, which we'll talk about in greater detail shortly. Prior engagement highlighted long permitting delays, lack of archaeologists, and again, the high costs. And so in order to do this, we proposed a single project-based permit rather than the current 3 permit model, the authority to modify permitting requirements, providing greater transparency in decision-making under the HCA, and greater regulation of the archaeology profession. In the wake of the devastating wildfire in Lytton and other natural disasters, we heard the need for better tools to address heritage during emergencies. This led to the creation of a new fit-for-use disaster response and recovery permit to better support communities, and new tools to allow for exemptions or modified permit requirements in emergency and/or disaster response and recovery scenarios. We also heard that better education and guidance around the HCA is needed. We are currently exploring the creation of a specific data layer and other systems and tools to support greater awareness, again, of heritage earlier in the process. We know that new and improved guidance and outreach is needed to continue to educate people about the HCA and to support implementation of the new changes. So with respect to permitting, we know that the permitting regime right now is administratively burdensome and complex. Decision-making and criteria are unclear, and some projects require up to 3 separate permits, resulting in incredibly long wait times. These issues have led to inadvertent impacts to heritage and difficulties for people trying to navigate the permitting process. Establishing a more transparent, consistent, and streamlined permitting process will benefit all who interact with the HCA. And to be clear, changes being contemplated will not remove our requirement to consult with First Nations. The objectives of the policy proposals under this theme are to clarify First Nations' role in permitting decisions and to make permitting more transparent and efficient for all parties. So here is a diagram kind of showing our current state versus what we're proposing. So currently, the province may require up to 3 types of HCA permits for a single project: an inspection permit, an investigation permit, and an alteration. This is cumbersome, and it adds to the timelines and the development costs of a project, as well as being challenging for the archaeology branch to administer. And for those of you who've navigated the HCA permitting process, you may know that each of these permits can take up to 300 days to be issued. We're proposing to replace these 3 permit types with a single project-based permit. This would last from the start of the project intake, all the way till its end, and follow it through its various phases of advancement. That will allow us to track together for all parties, including the proponent archaeology branch and First Nations, to reduce confusion. This will also reduce the number of overall permit applications by around 1/3, and when combined with changes that the archaeology branch is already making to its policies, will reduce the overall number of amendments by 60% or more. These legislative and the policy changes, in conjunction with some of the systems improvements that are underway, will significantly reduce timelines and reduce costs for proponents. And one benefit of this new permit structure is that by having one project-based permit, proponents will only have to wait, again, for 1 permit intake. Any necessary amendments would go straight to the archaeologist in the archaeology branch looking after that permit. And that will eliminate a lot of duplicative administrative work that is currently being done within the Ministry of Forests. The combined permit will also provide greater flexibility for different types of projects to move through the permit process in a way that makes sense for that specific project. For example, for some projects where there's a strong understanding of project scope and impacts to heritage from the beginning, we may be able to move through the stages of the permit far more quickly. In addition to the single project-based permit, we're proposing to introduce several fit-for-use permits. The first of these is to codify the multi-project permit framework, previously referred to as a multi-assessment or a blanket permit, to provide greater transparency and an enhanced notice of intent process. As with the project-based permit that I've just described, this will combine the existing 3 permit types without compromising consultation opportunities. Secondly, we're looking to introduce a conservation and research permit. This is intended primarily to support First Nations with their cultural work or for work that is more research-based. And thirdly, a disaster response and recovery permit that is intended for emergency management and disaster scenarios. Additionally, to provide greater flexibility in permitting, we're proposing to create a regulation-making authority, and this would allow modifications to the permits for specific circumstances. So, for example, this could be used to reduce requirements for archaeological work when proponents are using low-impact construction methods. This could be building within the existing footprint, building on slab, building on imported fill. And the details of these specific exemptions and or requirements would be detailed in a regulation that we will be consulting on at a future date. So currently, the process by which decisions are reached and what factors are considered is unclear. We're proposing to lay out in legislation the process currently used for consulting First Nations, as well as the decision-making criteria. In previous sessions, we've heard some concerns around the language used to describe the consultation process. We've taken that feedback away and will not be using the term consent seeking. The consultation process to be outlined in legislation will reflect the province's current practice in fulfilling its duty to consult. The original intent was to outline the current practice, and our current intent is still to do this and to ensure that the role of First Nations in decisions is clear and that it is transparent to the public. What is changing only is the wording we are using. I want to be clear that it does not mean that a permit decision will not move forward if there is not consent from a First Nation. We have quite a long list of criteria that are under consideration for statutory decision-making. I'll list a few here, and these are not ranked and they're in no particular order, but they include consideration of First Nations information, knowledge and policies, site significance and heritage value, public interest, site avoidance, or the degree of minimizing disturbance to heritage sites, cumulative impacts to affected sites, whether or not First Nations have provided their consent or not through consultation, any negotiated mitigations, accommodations, or offsets. Let that tray go behind me. And any existing agreements and or heritage management plans that may be in place. Additionally, the province recognizes that many proponents, and especially local governments in this space, engage with First Nations in advance of applying for a permit. This can be to provide project information, to discuss the proposed work to be conducted under a permit, for the involvement of First Nations, and in some cases agreeing to arrangements or other compensatory conservation work to mitigate the impacts of development on heritage sites. However, the province is not always aware of these conversations and these arrangements and lacks the ability to take account of them when processing permits, sometimes leading to a duplication of effort. We're proposing to introduce a record of engagement so that pre-application engagement can be taken into consideration in permit applications, consultative processes that the province is leading, and to statutory decision-making. This does not require the proponent to undertake consultation. The record of engagement could simply state that no engagement has taken place. But again, we're looking to encourage this practice and have a means by which to account for, again, some of those really constructive conversations that are underway with the hope of streamlining consultative timelines and decisions. The process will not replace existing consultation requirements of the province. But again, in some of these circumstances, it will streamline it. We're also proposing to bolster the province's ability to issue permits with these pre-agreed upon compensatory conservation measures. And to support this, we're looking to kind of broaden the definition of conservation in the HCA. And for example, this type of pre-negotiated accommodation work could include site recording and excavation, specialized analyses, or repatriation of belongings from a heritage site to a First Nation. Our final proposal under permitting is to clarify the minister's authority to regulate the archaeology sector and to enable the charging of registration fees to regulated archaeologists. Currently, the minister's regulatory authority is largely derived through his authority to issue, deny, and revoke permits. There's no regulatory process or structure that provides consistent accountable and progressive sectoral oversight. By clarifying and codifying the minister's authority, the province can improve regulatory oversight and establish a clear, consistent, accountable, and culturally responsive regulatory framework for the archaeology sector. Substantial work and engagement will be necessary to define the regulatory process and administrative mechanisms. This work is expected to be underway shortly and will begin defined through regulation. Engagement with First Nations, the archaeology sector, and stakeholders will occur at this regulation development stage, which is anticipated in 2026. And one thing, just to be responsive to some of the kind of questions and comments that we've been receiving through engagement to date, is how would this affect the supply of archaeologists? And so I want to emphasize that this work is anticipated to consider recognition and transferability of skills and experience from other jurisdictions, and also include the identification of cultural, experiential, knowledge keeper equivalencies to recognize First Nations' role in cultural heritage management. In addition to the changes proposed under the HCA reform, we did want to identify a number of operational changes that are currently underway to further reduce administrative burden and improve permitting timelines. At a high level, this includes application process improvements. These application forms have been updated with fillable PDF templates, getting to the 21st century. Clarified guidance has been developed, and a change made to establish a baseline 3-year term for heritage inspection permits instead of the previous 2-year term. Administrative extensions have automatically been issued for 150 permits expiring in 2025, and this has prevented expiry-related delays. The province is also actively working to update the archaeological permitting tracking system, which is a system to maintain all of the permit applications. It's quite antiquated and has resulted in a lot of manual duplicative work within the ministry. So this new system will improve permit tracking. It'll automate those time-consuming administrative tasks currently done by staff members, which will in turn free up time for higher value work. It will also anticipate better workflow management and consultation coordination. In terms of actions to enhance, again, kind of coordination across the line, the province has been piloting the bundling of consultation initiatives between forestry and archaeology information packages to streamline permitting. And we're looking to explore other opportunities across the natural resource sector to reduce turnaround times for permitting decisions. As discussed on the previous slide, the province will be clarifying the authorities to regulate the archaeology profession, but this will also include updating the standards and guidelines for archaeological work. And the idea here is to provide greater consistency and rigor in the archaeology work done across the province. So these changes, in addition to the legislative and regulatory changes I've summarized, are anticipated to support quicker decisions and reduction of costs. So our second topic is around helping people and communities rebuild after disasters. Currently, it can be challenging for the province to swiftly issue permits in an emergency situation. This can lead to delays and unexpected costs when communities respond and rebuild. To allow the province to be more responsive in emergency and disaster situations, we're proposing to create an authority of the minister to make exemptions to the permitting regime in certain circumstances. And those circumstances will be detailed in an accompanying regulation. Some examples of where this power might be used include where there's an imminent threat to life or public health that justifies an immediate response, such as if a sewer line bursts within a heritage site. This would also allow the problem to be fixed as quickly as possible. Or we can imagine a large disaster caused by a wildfire, an earthquake, or a flood where the minister might adjust permitting to support the recovery efforts of communities and other ministries. As mentioned earlier, the disaster response and recovery permits are intended to provide easier access to HCA permits for communities recovering from a disaster, and the regulation-making authority to modify permit requirements could also be used to reduce the burden on homeowners who are rebuilding in these circumstances. And so with that, I will hand it over to my colleague Elizabeth to run through the remainder of our proposals. Thank you.
Hi, thanks, Jess. Just adjusting my mic, bringing it a little closer. My name is Elizabeth Scambler. I'm the Director of Policy and Legislation with the Heritage Conservation Act Transformation Project, and had the pleasure and honor of working on this project for a couple years now. I wanted to start by speaking to some of the items related to ensuring greater awareness of risks to heritage and proactive due diligence measures. We know that heritage considerations are often identified late in project planning processes, leading to project delays, cost increases, contraventions of the HCA, and damage and desecration to First Nations heritage sites. There can also be inconsistency in the way that local governments manage archaeological considerations, particularly during the development approval process. The objective of the proposals related to due diligence are designed to ensure greater awareness of risks to heritage in advance of land use planning decisions and to ensure proactive due diligence in heritage management. So the intention here is to ensure early awareness of heritage site potential and responsibilities under the HCA. Currently, there's no requirement for approvers and local governments to see proof of an archaeological data check prior to issuing development and building related permits, meaning that a local government can approve a project and issue permits without the applicant ever being notified of potential archaeological concerns. This can mean that heritage considerations, such as the presence of a protected heritage site, may be identified late in the project planning process, perhaps even during construction, leading to delays and increased costs. We're proposing to require local governments to see proof of an archaeological data check prior to issuing development and building related permits and authorizations. We would also be requiring subdivision approval authorities to see proof of an ARC data check prior to approvals as well. We also propose to create a regulation-making authority to require mandatory checks in certain circumstances. This could include the sale of property, as well as for certain entities such as crown corporations or major infrastructure operators. We want to note that many local governments, realtors, crown corporations, critical infrastructure owners and operators are already undertaking their own archaeological data check process and due diligence processes and use mechanisms to ensure compliance with the HCA. The intention of these is to ensure greater consistency across the board in terms of when archaeological due diligence takes place. The regulation for the duty to check will take some time to develop, and we will be working with our partners to ensure we're integrating appropriate implementation considerations like training for each sector and making sure that that's in place before the regulation would be rolled out. So let's talk a little bit more about what a data check is. Archaeological sites in BC are culturally sensitive. Many contain ancestral remains and have important and sacred value to First Nations in BC. We realize there's been a bit of a confusion about the difference between what an archaeological data check is in relation to other types of archaeological assessments. So just to clarify, there are several data systems that allow authorized users to view and download spatial and tabular data about archaeological sites in BC. Currently, many local governments already have access to these systems. I think like over 120 local governments BC already have access to these systems and are using them on a regular basis. Due to the sensitive nature of heritage information, access to these systems are restricted on a need-to-know basis, but qualified parties like private property owners, prospective property buyers, industry, land title, conveyance professionals, Indigenous, local, and provincial government staff can ask for archaeological information and advice on a specific property or area. So the data check involves a scan of the Provincial Heritage Register for whether a property or area intersects with a recorded protected heritage site to identify potential risks to as yet unknown heritage resources. This service, currently provided by the Ministry of Forests to get an archaeological data check, is free of charge, and the current estimated response time is around 6 business days to get a response from the Ministry of Forest. I also just want to clarify that an archaeological data check is not the same as a detailed archaeological overview assessment or archaeological impact assessment, which may require actually hiring an archaeologist, but the data check is like a desktop check of existing geospatial data and does not require hiring an archaeologist and is conducted free of charge. So as we talked about earlier, we've heard from local governments that there's a desire for more proactive tools for heritage planning and protection. We're proposing to enable in legislation a framework for the development of heritage management plans. We recognize that many local governments and proponents have unique relationships with First Nations, and that this is just one way that we want to try to recognize and enable some of the things that are already happening in communities. The intention is that heritage management plans could be developed with multiple partners, such as First Nations, local governments, proponents, and the province. And the details related to what would be included in a plan would go out in regulation. By recognizing these plans in the HCA, the province would be able to consider them in permitting decisions, supporting greater certainty for project planning and decision-making. Examples of where this tool could be used include supporting land use planning by local governments, by identifying how different heritage areas are to be managed before any land development works begins, and also for supporting the management and ongoing use of heritage sites within municipal parks, as an example, or to support major project proponents in developing large and complex sites by identifying appropriate construction methods or certain conservation methods in advance of that project starting. An additional key objective of the Heritage Conservation Act Transformation Project is to support consistency between the Heritage Conservation Act and the UN Declaration on the Rights of Indigenous Peoples, and to affirm and recognize First Nations values and rights in the transformed HCA. There are a few areas that we're proposing changes under affirming First Nations rights. So first, we're proposing to add an affirmation and principles statement that affirm First Nations rights and set out principles that are intended to be the lens through which the entire act would be interpreted. These cover cultural heritage rights and other principles related to data sovereignty, place names, repatriation, and minimizing disturbance of cultural sites. Second, we're proposing to affirm First Nations as decision makers regarding where their ancestors and belongings are held and cared for. Currently, belongings must go to an approved repository, such as a museum, which excludes many First Nations who want to care for their belongings in their territory or maybe even rebury their own belongings and ancestors. We're creating a process where First Nations can predetermine where items collected under permits will be held and how they'll be cared for. Third, we're proposing to better protect the confidentiality of Indigenous knowledge and heritage data that is shared in confidence with the province. First Nations are concerned that information they share with the province isn't being held confidential. We're proposing to confirm the legislative requirements that Indigenous knowledge and heritage data provided in confidence to the province remains confidential and is only used for its intended purpose. Currently, there's a number of protocols in place related to this already, but we want to confirm that in the legislation and affirm that First Nations have a right to maintain the confidentiality of their data. Fourth, we're proposing to remove barriers for First Nations seeking to manage their heritage sites on Crown land in situations where the detrimental impacts to the site are minor or low risk. Currently, First Nations are not always recognized as experts in their heritage, and it can be really costly and time-consuming for First Nations to manage their own heritage sites through the permitting process on Crown land. There are barriers to First Nations who wish to collect their heritage belongings that might be at risk of imminent loss or destruction as well. We propose to clarify in legislation that certain prescribed activities conducted by a First Nation on Crown land do not constitute an offense or require a permit. Some examples of these types of activities are clam garden revitalization, maintenance of a heritage trail, and the ability for First Nations guardians or other suitable individuals to collect surface objects at imminent risk of loss or destruction, such as due to tidal erosion. To further strengthen the role of First Nations in the management of their cultural heritage, we're proposing to enable a suite of agreement types to address First Nations' distinct interests and strengthen First Nations' role in decisions affecting their heritage. First, Declaration Act agreements would enable a nation and the province to agree upon a framework for joint and consent-based decision-making for certain decisions under the HCA on Crown land. For example, a permit pertaining to an ancestral remains site in a BC park could be eligible for one of these agreements, or designating an important cultural site on Crown land. These requirements would all require a mandate from Cabinet to start negotiating, and again, would only apply on Crown lands and would not apply on private land. The scope of decisions to be considered for Declaration Act agreements is still being determined, and we're seeking input on this through this engagement process. Second, we have jurisdictional agreements. So jurisdictional agreements would enable recognition of a First Nations jurisdiction over a defined area, again, on Crown land. They would allow for the HCA or sections of it to not apply in a defined area. For example, a nation's heritage permits could apply instead of HCA permits, and the First Nation could use its own guardians for compliance and enforcement within the agreement area, again, on Crown land only. Like Declaration Act agreements, these would all require a mandate from Cabinet to start the negotiation process. Third, operational agreements. So these currently exist under the HCA as Section 4 and Section 20 agreements. And they currently apply to both Crown and private land. We're proposing to continue these agreements as under a new umbrella term called operational agreements that will cover operational matters to be administratively easier to negotiate than the current agreement types that exist under the HCA already. Depending on the scope and the scale of the proposed agreement, operational agreements may not always require a Cabinet mandate prior to negotiation and may sometimes be approved by the minister or their delegate. These types of agreements, like they currently do, would continue to apply on both Crown and private land. Operational agreements could include a variety of operational matters. These could include enhanced protection measures, such as putting up a fence or a sign on Crown land, the ability to use, the ability for continued use of sites under certain circumstances, provisions related to the specific collection and care of belongings or ancestors, and policies that the provincial decision maker could consider with respect to decisions within the agreement area. Operational agreements could also include public education agreements where a First Nation and the province agree to co-create educational materials for a provincial park, for example. They could also include things like information sharing during compliance and enforcement activities so that a First Nation and the province could have an agreement to share information about a compliance and enforcement investigation in a nation's territory. Prior to decisions being made to enter into any of these agreements, consultation with all affected parties and an analysis of the implications will be required to inform a decision on whether or not to proceed with an agreement. Additional details would be prescribed in regulation, which could include circumstances where these agreements can be negotiated, general scope, and factors that would have to be considered prior to negotiation. For example, mutual readiness or agreement that the affected First Nations have agreed amongst each other about their readiness to enter into this agreement. So let's talk about the measures we are proposing to protect heritage more effectively. The changes to the HCA to clarify the existing protection regime are to clarify the existing protection regime, but not expand it. We propose that the existing pathways to recognize and protect certain types of heritage will be more clearly and more transparently laid out in the legislation. This includes updating the definition. So currently the definition of heritage in the HCA is fairly nonspecific. It speaks to sites or objects with heritage value. Moving forward, we're proposing that the definition of heritage be broadened to include reference to a broader range of heritage values, including sites of intangible heritage. So this includes cultural landscapes, mortuary landscapes, and other values important to First Nations. I want to clarify that broadening the definition of heritage does not increase the scope of protections under the Act related to heritage. Currently, there are several pathways towards recognition of protection for a range of heritage values under the HCA. Those are automatic protection, which includes burial sites, and this is current. So currently, the HCA automatically protects burial sites and rock art, regardless of their age, as well as other sites that predate 1846. Another pathway is order and council designations that allow for case-by-case designation of cultural heritage sites that might not meet the criteria for automatic protection. That process exists already. And agreements with First Nations to also, on a case-by-case basis, create specific protections for sites that might not meet the threshold for automatic protection. These mechanisms for protecting sites are not changing. For automatic protections, we're proposing to maintain the existing automatic protection system. We're not expanding the scope provided under the HCA, but we will be looking to just clarify the existing and current scope and make sure that it's transparently laid out in the legislation. For site designations and protections via agreements, these will continue as available tools for case-by-case site designation or site protection mechanisms for sites that might not be subject to automatic protection. And just like they do now, these sites could include sites of intangible heritage. We want to clarify that in the legislation some of the procedural requirements for seeking a site designation. And this could include enabling the minister to approve some site designations instead of going through the extensive cabinet process. All site designations and all protection of sites via agreements would be subject to a very robust implications analysis and consultation with all affected parties prior to a decision being made on whether or not to move forward with that site designation or protection. So the legislative amendments we are proposing here largely serve to clarify the existing pathways available to protect these sites. We also want to clarify the legislative pathway to recognize cultural heritage practices. And this is a process that's kind of exists already under Section 18 of the Act to promote things with heritage value. We want to expand this to ensure that this remains to be an educational tool to promote a variety of different cultural practices that could include things like songs, ceremonies, foods, and traditions. And again, this is more of an educational tool than it is a tool that creates any obligations on other parties. So this tool that would recognize some intangible heritage practices like songs and ceremonies would not require any third party or restrict a third party from accessing these traditions as well. Another proposal is to, through regulation, explore mechanisms to vary protection criteria and permitting requirements based on heritage value and conservation goals. This would be done through regulation, and it could be that in a future regulation, we could identify sites that meet certain criteria to receive greater protection, such as Indigenous cemeteries, for example, and maybe prescribe enhanced avoidance and mitigation measures associated with those types of sites. The regulation could also identify sites that meet a criteria to be preserved via record only and require only minimal mitigation measures. So this could include, for example, culturally modified trees that have been impacted by wildfire or pine beetle, where the site itself doesn't actually need preservation, but the record of where those culturally modified trees are is really what's important in that instance. This regulation would be developed in the future in consultation and cooperation with First Nations and with input from stakeholders and local governments. We're also proposing to clarify how fossils are recognized under the HCA. We want to ensure that important fossil finds can be designated as protected sites, just like there is one fossil site, the Maccabi fossil beds are designated as a protected fossil area currently. And we also want to ensure that fossils could be included in a future duty to report. However, fossils and paleological finds would not be automatically protected under the Act. So currently there's a lack of transparency and clarity about how site boundaries are defined and how these site boundaries determine permitting requirements. We're proposing to codify how site boundaries are defined in legislation. These administrative boundaries would continue to be based on areas where there is recorded physical evidence. However, in order to reflect that the presence of heritage sites likely extend beyond areas of recorded evidence, we're proposing to establish a concept called heritage management zones within the Provincial Heritage Register. These could include areas that are reported to contain heritage value but have not yet been verified in the field. So as you can see in this hypothetical example on the right of the slide, we might use a heritage management zone in yellow to fill in the spaces between investigations where the heritage site is likely to extend but has not yet been verified. In regulation, we'd be proposing to prescribe requirements associated with these heritage management zones. This could include the ability to require an archaeological data check or potentially compel some level of archaeological work only in certain prescribed circumstances, such as where there's imminent threat or risk to heritage values. More policy work and engagement on heritage management zones will be needed as this concept is fleshed out earlier. But this is a concept that we're putting out into the world and engaging on and hoping that our partners can help flesh it out further for us. Something that we've heard from many partners in earlier phases of engagement was that the current compliance and enforcement toolkit is lacking and doesn't have enough teeth. Issuing violation tickets and penalties for contraventions of the HCA is not currently enabled, and so we want to bring this tool into the toolkit. We'll also be exploring opportunities to direct any violation ticket fine and penalty revenue to support the remediation of impacted heritage sites through dedicated sub-accounts. Although it is currently an offense under the HCA to damage, excavate, dig in, alter, or remove items from a heritage site, there's no legal requirement to report finding one. An example of this could include someone finding a projectile point in their private garden or a cultural belonging found on the surface of a trail. And by introducing a duty to report these finds, this would help counteract a growing narrative to hide any heritage finds that you might find on your property, as well as to lead to more effective decision-making around sites earlier on in project planning. Currently, there's also no prohibition on the possession, sale, and trade of heritage belongings. This is a major gap in the legislation to date. Currently, there's no legal tools when folks see a Craigslist or a marketplace ad for belongings. And the burden of kind of tracking down where these belongings should go often falls to First Nations to attempt to educate the public and encourage them to turn in any heritage objects that they may have in their possession. Some additional items that we want to clarify in the Compliance and Enforcement Toolkit include enhancing permit enforcement and auditing measures, clarifying some of the rules for stop work orders, and amending and enhancing the HCA to address and guide the collection, treatment, care, and disposition of collected, seized, or forfeited heritage objects to a repository or to descendant communities. So let's look a little bit at the current toolkit. Although there are some helpful compliance enforcement tools under the HCA, like the ability to issue stop work orders or the voluntary process of restorative justice, you'll notice that there's a pretty large gap between a compliance notice, which is essentially a written warning, and taking someone to court for formal charges. So we need more tools in between to address offenses that are smaller and less egregious in nature, or where we don't think that formal court prosecution is the right fit for the offense. Introducing more tools would fill in the gaps and bring our legislation into alignment with other natural resource legislation. So again, this includes adding the ability to issue violation tickets, administrative monetary penalties, clarifying some of the rules for issuing and extending stop work orders. We also want to clarify the authority to publicly disclose specific information related to persons who contravene the Act. This could look like posting the names or businesses or organizations of folks who have committed an offense on a website. And this could be a really strong deterrent to committing an offense under the Act. We hope to enhance the Compliance and Enforcement Toolkit to be more responsive and tailored to the severity of offenses and to encourage compliance with the HCA.
Elizabeth, can we just do a time check? How many more slides do we have here?
I think we're just coming to the end.
Okay.
Yeah. Okay. So that comes to the end of our overview of the policy changes, but we wanted to give you guys a bit of a sneak peek of some of the early findings of what we're hearing from local governments so far in this engagement process. There's been great participation so far with over 194 attendees attending some of our virtual engagement sessions representing 83 local governments. And of course, we have all of you here today. These are just a few preliminary findings, but I do want to clarify that no legislation has been developed and we haven't actually done anything yet with this, but we wanted to ensure that you guys are hearing what it is, some of what we're learning, so that we can also validate that together or workshop what else is needed. So we're hearing that some of the concerns we're hearing concerns that the new requirements could further impact permitting timelines and costs. We do believe that while there are a few pieces in the proposed changes that increase process, that overall we're making a significant impact to the permitting process by reducing the overall number of permits required, including the ability to modify permit requirements during certain circumstances, including emergencies. And we also really believe that greater regulation of the archaeology profession will enable better cost control tools. These changes, in addition to parallel operational improvements in the archaeology branch, will significantly reduce permitting timelines and cost to proponents. We're also hearing that local governments are looking for resources, tools, and training to implement the new HCA, and we'll be committed to developing the guidance and training that will be needed to implement any changes. We're also considering how to phase the implementation of the legislation in, including phasing the development of regulations to ensure that guidance and training can be developed before, or like in line with when requirements are introduced. Local governments have also been providing great ideas to enhance public education and awareness for all parties. This includes looking at some successful education campaigns, like even partnering with campaigns like Call Before You Dig, or looking at existing geospatial mapping tools such as the LTSA's AutoProp tool to support the due diligence checks for all parties. We've also heard that in order to implement the data check requirement, that local governments and other partners need improved archaeological inventory databases. So again, we're exploring phased implementation of requirements to ensure that we're bringing requirements in when the appropriate tools are in place for people to help fulfill these requirements. We're also hearing that the need to continue to engage local governments in regulation development and implementation. So as was announced yesterday, the engagement window to engage on these legislative changes has been extended until November 14th, and we do anticipate that more engagement with local governments would also take place when regulations are developed. So maybe with that, I will hand it back to our moderator.
So now we'll have some time for some questions. When you approach the mics, we have two mics as well. We have Slido. Please state your name and the name of your community. I would also ask delegates to respect UBCM's rules and procedures, which stipulate that only those who are elected officials from local governments and member First Nations have the privilege of the floor. So I know that there's a number of industry people here, but unfortunately we only have time for questions and from our elected representatives. And please again state your name. And I'm going to start over here with Mayor O'Connor.
Oh, thank you. Denise O'Connor, I'm the mayor of the village of Lytton. So we know that there is a huge financial burden on the municipalities and on homeowners, and it's extremely concerning. So will the act be changed to minimize those costs? For example, not just speeding up time, for example, looking at already disturbed soil. So for example, in our municipality, we do a sewer line repair, and then 10 years later, we have to do another sewer line repair. Will the act eliminate that so that there's no more ARC required, no more costs associated with that? Thank you.
Thank you, Mayor. I'm very well aware of your particular situation. I think that there is one tool that we're looking at around modified permitting requirements for low impact work. So for example, in a situation where you have imported fill and you're building back into either the imported fill or the existing footprint or the previous footprint, these types of like low impact work, we are looking at modifying permitting requirements for that, potentially up to including not requiring permits for certain work. It won't be, I can't say emphatically across the board exactly how that will apply yet. We have some work to do, but we recognize that there's some situations where there's incredibly low impact to the ground, and we want to make sure that that's reflected in the permitting process. Because right now, there's just one permitting process, and it applies across everything that we're doing, regardless of what the impact on the ground is.
Okay, thank you. We'll go over to this mic.
Thank you, Mayor Paul Horn, Mission. Your presentation has focused, and the work appears to be focused largely on archaeological analysis, and certainly that's important for us in our community, and I'm embarrassed to say this. We had a heritage protection strategic plan brought in 2008, and we are still, 18 years later, unable to bring it forward just because the tools and the resourcing to bring those tools are so convoluted for those sites that are known to us, heritage buildings, established heritage sites. Will there be work done to clarify and simplify the tools that are available for protection of heritage sites and to provide resources to communities that want to advance that work?
Thank you so much for the question. So you're absolutely right. Most of our focus has been on First Nations heritage. Our sister branch, the Heritage Branch, deals with a lot more of the kind of non-Indigenous sites in the province and like the historic buildings and the like. I think it'd be really helpful to maybe chat with you after the session, get a little bit more detail to speak to them about any potential improvements that can be made in that space.
Okay. Thank you. Okay, we're going to the Slido question that comes from Will Cole Hamilton of Hamilton. Could operational agreement recognizing that First Nations permitting process are sufficient and HCA permits not required be made between First Nations and BC over non-Crown land?
Yeah, I'll take that one. So right now, we can do that under the HCA. It requires the consent of the property owner, and we'll be looking to maintain that. We actually have, we've never done this before, but there is currently one situation underway where a private property owner wants to use this mechanism, and we are trying to facilitate that. So we can do it under the HCA now and wouldn't be looking to change that.
Okay, thank you. Go over to Councillor McAvoy.
Jamie McAvoy, New Westminster. We have the first city in British Columbia. We have 13 First Nations that lay some claim to New Westminster. 3 of those First Nations believe that they are the one and only First Nation that is legitimate, has a legitimate claim to that hunk of territory. It's easy enough to consult with all 13. How are you going to decide who gets an item?
Okay, so
Right? This is a question we can't resolve as a city, really. And so it's not the only place in the province where this is the case. Even when the Nisga'a Treaty was done in the 90s, there was 2 other First Nations that contested part of that territory. So how would we resolve that if, First Nations are allowed to send qualified people to look for items, or if items are found in an archaeological dig? It's something we would need some guidance from the province about, I think.
okay. Or who would make that decision? So I'll turn it over to you.
Maybe I'll start and then feel free, Elizabeth, to jump in. So we spoke a little bit about the opt-in framework. So I suspect, Jamie, that's what you're referring to. And so for First Nations to opt into that framework, there would be certain kind of preconditions that would need to be met. So we would be looking either for that to be in an area of non-overlap or to ensure that there was agreement with neighboring nations prior to entering into such an agreement. So if one of these was not entered into and wasn't active in the area, we would kind of default to the current process, which is using like a local repository like the Royal BC Museum or some other local museum to kind of care for these items. Elizabeth, is there anything you want to add?
Go over to this mic.
Good afternoon. My name is Ron Cannon, Kelowna City Councillor, former Land Title Survey Authority of BC Board Director, and spent about 10 years as a member of Parliament. So I understand when you get into policy, kind of policy wonk, you start unraveling this. I understand the spirit and intent of protecting heritage property. So 2 questions. One is specifically in our community, Bill 47 allows, it's a transit-oriented development areas, allows 6-story buildings without parking to be constructed within our heritage areas. And it's a real concern. We're going to, basically ruin the form and character of our heritage areas. So I just wonder if there's any potential conversations about amendments to allow local governments to change or to transfer density within heritage conservation areas to another part of the city. We're not against densification, but we want to protect our heritage area. And right now we don't have that ability. So we're just wondering if that's a possible amendment.
Yeah, this piece again falls more under the Heritage Branch, and so maybe we can connect after and talk a little bit about that, because we don't have a Heritage Branch representative here, but we want to make sure that we can connect you with the right person or better understand the current situation.
It's disappointing that nobody's here for that, but the other one is that we've heard from local governments, BC Real Estate Association, I'm a director of a mining company, independent contractors, a business association, many other organizations have expressed concerns with the proposed changes, and Minister Palmer and others have indicated that consensus has been reached on 53 of the 57 proposed legislative changes. So with whom has the province reached this consensus?
Yeah, just to clarify that, it's not consensus on what will move forward. It's consensus on what to come and talk about in terms of proposals. So nothing has been drafted. There's been no decision made by government to move forward with these yet. We have to complete this engagement first. We have a joint working group that includes members of the First Nations Leadership Council and BC. We worked together based on what we heard through the first 2 rounds of engagement with stakeholders and local governments as to what the issues are, what issues we are hearing from First Nations about the Act, and we have put those together into these proposals. It doesn't mean that all of these proposals will move forward. It's just what we have in terms of a scope to engage on.
Thank you.
Go over to the next mic.
Good afternoon. My name is Lori Hopful. I am the mayor of Lillooet. Our infrastructure is old in Lillooet. Our pipes leak. We have found skeletal remains when we've had a pipe leak. So our cost should have been somewhere between $6,000 and $8,000, and it was substantially more because once we found that, what follows is extensive and extremely expensive. So our little rural community cannot afford this, and we can't. It's going to happen because our entire town is in a red zone. So every time we dig, every time we find something, it's going to cost us more and more money. So my question is the province looking at helping small rural communities like us and other rural communities? Thank you.
Money questions are the tough ones. Sorry. Okay, who wants to take that one?
Yeah, thanks so much for the question, and that's definitely a tough one, and I know you're not alone in that scenario. So I think there's a few pieces here. One is, again, indirectly, we're looking at ways to reduce costs. Again, when one is entering into the permitting system, having a more cost-effective, more streamlined process that will save money when entering and requiring a permit. We also talked about the modified permit requirements regulation. We mentioned in the context of disasters, and I think it applies in a variety of scenarios, again, where there's infrastructure within existing footprints and being able to, again, identify some scenarios where there may be reduced HCA requirements, which in turn reduce costs. And then I think the third piece is around the standards and guidelines work that we were referring to in conjunction with greater regulation of the archaeology profession. We know right now there's a lot of inconsistency in how archaeology is done throughout the province, and sometimes that can result in incredibly high costs. And so the idea here is, again, to create more rigor and consistency in how archaeology is conducted, and to have standards and guidelines that really kind of outline minimums and outline maximums and provide, again, more of a thoughtful approach to some of this work, especially, again, in areas that have been previously disturbed.
I'm going to insert my privilege as chair to ask a question, because I actually have a house that was being built and have 60 artifacts identified, including a full ancestral burial. So my question is, you mentioned the changes for archaeologists and doing more in the way of registering and more work with the profession. Have you considered in that also using archaeologists as certified professionals so that they can do more evaluation in the field as opposed to having to send regulators and people from the branch out to do site? I know it's done in other areas around stream side setbacks and around arborists, but have you considered using archaeologists through your changes and the governance over that profession, using them as field experts and actually working on your behalf, not just on behalf of the client? I'll go to the next mic. Okay, worth writing down.
Do you want to respond to that, or?
I think it was a new idea, so I'll just throw it out there as for consideration, and let's go to the next mic.
Okay. Good afternoon, everyone. My name is Tanner Timothy. I'm legislator with Tla'amin First Nation from the Upper Sunshine Coast. I just wanted to provide a kind response to the first question. Doing archaeological assessments is really important in the context of installing infrastructure and then revisiting years later. As a lot of you can appreciate, the infrastructure that was built over the last 50 plus years didn't have archaeological assessments. And even in heavily disturbed contexts, we do find artifacts and often ancestral remains. In the example in Metro Vancouver on the Hudson Force Main, there was actually a sewage leak in the sanitary main. An emergency repair had to be done, and they found a number of ancestral remains within the excavation wall of where they went to go access the main and replace the main. And they've been doing a series of screenings of that sediment and collecting the ancestral remains. There's been a series of there's been so many remains, fragments found, ancestral remains, that have been verified. And there's been a lot of cultural protocol to even honor that. But that being said, it's an example that even in disturbed contexts, you can find archaeological remains and ancestral remains. And that's why it's so important to conduct archaeological overview assessments and archaeological impact assessments, and then following the recommendations put forth by a professional archaeologist. Also in tandem, working with First Nation monitors and their own experience. And that can really inform and help understand a project, a right-of-way of utilities, and even 10 years down the line when you have to go there and do more work, you're more cognizant, you're aware, you have knowledge of that piece, or at least the main in itself, and you can go off the recommendations of work that you've previously done. And then working under the HCA, if it happens to be a registered site, you can apply for a site alteration permit and then proceed properly with proper due diligence. So I just wanted to share that because it is really important, but I do really appreciate the perspectives like merit in those contexts as well. I just wanted to share the importance of doing these assessments. For us, archaeology, well, for us, I mean First Nations people, our archaeological sites are one of the last standing examples of our land use and occupancy and presence in life. Being through residential school and having our culture suppressed and removed and our languages heavily damaged, these artifacts and belongings speak to our life and presence and are sacred to us and have meaning, special meaning. And honestly, we just really want to work well with one another and to help proceed projects, but also care for these things because a lot has been lost, but if we can preserve archaeological sites and cultural sensitive belongings, it means a lot as well, just for us to be cognizant of that. But thank you.
Thank you for your comments. That's good.
Could I say
Sure, yes,
something?
please.
Sorry. Thank you for that comment. And this is exactly why we need to be really mindful when we're developing regulations around things like modified permitting requirements to make sure that we're not missing that important context. So thank you for that.
Thank you. Okay, we'll go to this mic.
Yeah, John Jack, Chair of the Alberta and Clayoquot Regional District and Chief Councillor for the White First Nations. I just had a question in regards to some of the questions around, I think it was a local government would be replacing a sewer line or something and they found a skeleton. Costs notwithstanding, I think it's worth the costs, regardless of who has to pay. That's not what I'm responding to, I guess. What I'm wondering though is that I think part of what these amendments are for, to make sure that the Crown stands by the requirement that they have to make sure that they respect reconciliation and doing well by their neighbors and First Nations. And so is it possible for local governments to enter into some of the agreements that were aforementioned and talk about instances of when that happens, have the conversation before it happens? And then you can, because I think no, I'm not worried, but I think a lot of people are worried that this is just going to increase costs and make things more onerous. If you do the relationship right, if you create an agreement where you can pick up the phone and have conversations with your Indigenous neighbors and friends, it might make things less onerous because all you might need to do is recover the skeleton, help deal with putting them in a good place to say goodbye, and then moving on. That's probably what I'd be worried about. Let's rebury that person and then rebuild that sewer system because I know how important that is to my community. But you got to have that conversation first. So I think this can actually create the framework for having those conversations, but you have to do political work to do that. And that political work will save the administrative costs. So think about what you can do, even if it's not defined, rather than just what it might stop. Because you can do good things and avoid costs in the future, sewage costs, or just the costs of a bad relationship. Right, thanks.
Anybody want to respond?
Yeah.
Yeah, thanks so much, and really appreciate those comments. I think one of the tools that that we're proposing to help support exactly some of the things that you're talking about is this tool of developing a heritage management plan, where there could be multiple parties. It could be, you know, specifically between a local government and a First Nation or a group of First Nations, to do exactly what you're talking about, to have those conversations in advance, to talk about the things that are tricky within, you know, the areas that you're looking at. That could include even, you know, like pre-working together on, you know, what happens when we need to repair a sewage line. How are we going to work together, and what agreements can be determined around, you know, maybe we want a little more enhanced archaeological work here. Maybe we're willing to, for there to be a kind of less intense archaeological work in another area. So like these are really meant to be collaborative tools, to be having those types of discussions in advance, and to promote, in many cases, some of the good work that local governments are already doing with First Nations.
Okay, back to the mic. Yeah, I think.
Sorry, I just had a follow-up question in regards to in terms of saving money and time, but also making sure that you're preserving the requirements of the Crown to do all the things that you're talking about, would we be able to agree to on experts that could come in that are mutually agreed upon, akin to the idea that you had, Mr. Chair? So, yeah.
My idea was, again, similar, but in the field, if an archaeologist says this area has been cleared and we need to explore another area, you still have to go back and get a new heritage permit, which is what I had to do. So an archaeologist in the field says, I know this site, I can evaluate it, but he was not authorized to override the heritage requirements, even though he was an expert in the field, because his qualifications aren't recognized by the provincial government in that way. Such as biologists are, they're able to give evaluations on streams and other things, but in the heritage side, we don't recognize the archaeologists the same way that we do with professionals in other fields. And that would save a lot of time in the field if we recognize them as independents. Their certification and their qualifications, like engineers and anybody else who stamps building plans, the ability for them to act independently and be recognized, I think is where an area that we could streamline the process.
And maybe I'll just say briefly to that, I know we talked a little bit around the work to enhance the regulation of the ARC profession and establishing a registry. So I think part of that is what you're getting to, and what we'll be fleshing out in the regulation is what are the criteria that'll be considered to be on this registry, having a registry that people can consult when they're hiring archaeologists for work, and also recognizing equivalencies of nations who have absolute expertise in this area.
Great, thank you. Let's go over to that mic.
Thank you. Pat Corbett-Labatt, District of Port Hardy Mayor on the traditional territory of the Quagga people. Thank you to, I'm sorry I missed your name, but your words resonated with me, and so did your words too. We do have a good relationship with our Quagga people, and they come out to the sites. My concern is the inefficiency with the archaeological permitting right now. And I believe it was Jessica, you said it's 30 days or 300 days. I beg to differ. 300 days times 3. I think another community I heard 300 days times 5. Not very efficient. So my question is, as the leader of the opposition said this morning in his speech, he stated he's going to fight any new legislation. My concern is the archaeological branch going to be more modernized as a priority, whether the legislation goes through or not?
That's a question coming up on Slido, so
That was me.
Oh, was that yours? Okay, thank you. I wasn't ignoring the question. I was getting to that next, but thank you for asking it at the mic.
Yeah, maybe I'll take that. And given that I'm a bureaucrat, I'll stay away from the politics. But yes, I think one of the slides that we had in the presentation that Jess spoke to was around some of the modernization that's happening in the archaeology branch right now. we can't wait for legislation in some spots. Like we have a pretty broken system. We have a branch that is incredibly overwhelmed, and we need to improve processes. Some of that can only be done through legislation, but we are doing what we can through other processes. We're streamlining application processes. We're moving to deemed authorization for things that are very administrative. We're pressing out timelines for permits from 2 to 3 years. So we're doing what we can, but we are limited by this very old, very clunky, works for nobody legislation. And so we will do what we can, but the real wins require legislative change.
Thank you for allowing me a second question. I hate to be overly persistent, but I guess every day you come to a conference, you learn something new. What I learned here, and the answer to my first question was new but not welcome. It's really strange to me that we have a Heritage Protections branch, we have a Heritage Conservation Act, and I'm looking for some clarity. We have Part 15 of the Local Government Act that deals with heritage protection, and now we have, well, not now, but we're looking at revisions under this act, which is under forestry. All of that perplexes me, and it seems to me that we haven't gone deep enough in terms of reconciling all of this legislation and in making it simpler for people who are interested in protecting heritage, period, whatever that heritage might look like. Can you give me a little bit of insight as to why it's handled differently, and advise us to whether or not there's an openness in government to reconcile those two very different approaches to heritage?
Yeah, maybe I'll start there. I appreciate the frustration, and it's potentially even confusing for those in government to figure out sometimes who to talk to under the HCA, because we do have different branches that have different functions. The Heritage Branch, as I mentioned earlier, deals more with kind of built heritage, with designated properties like Fort Steele and Barkerville, but they also have a geographical names program. They support fossils management. They have a bunch of different functions, but they deal, again, primarily with the built heritage and the non-Indigenous heritage side of things. At one time, many, many moons ago, the Archaeology Branch and the Heritage Branch were one together, and through like the last number of years, the sort of work has become a little bit more separated, and so our Heritage Branch colleagues are in the Ministry of Tourism, Arts, Culture, and Sport, and we are in Ministry of Forests. I will say, though, that we work very collaboratively with Heritage Branch, and they have been involved, and many of the sort of heritage stakeholders have been involved in the engagement on the HCA transformation project to date. So I think we are still trying to foster the collaboration, and if there are improvements or things that we can bring in terms of feedback that relate to their work, we're happy to be the messengers and connect you.
Back to Councillor McAvoy for another question.
Two things. One is, I'm wondering about the thinking of keeping the 1846 date, because my understanding was always it was intended to cover the pre-colonial period. Was about 15 years short to cover the pre-colonial period. So I wonder about that choice of date, because it leaves a pretty good chunk of time before my community was built. Victoria was incorporated 1862, so I would think that would have been extended to cover that sort of full pre-settlement period. The second is the practical aspect in terms of archaeologists. Like, if the amount of archaeological work has increased in the province, then the issue of recruitment, retention, who's paying them, because it's not great as a private practice to be an archaeologist. And most archaeology on sites in British Columbia is done by students under the supervision of an archaeologist, except for those kinds of independent assessments that Craig had. So I am wondering about the practicality of that, if this is intended to make it easier and speed things up, but it also sounds like it's creating a fairly big increased demand for archaeological work and assessment at the same time. So I'm just wondering what your thoughts are on that part of it too. Thank you.
Do you want me to jump in? Okay, so maybe thanks so much for both questions. With respect to the 1846 date, That refers to kind of the assertion of British sovereignty. That's where that date comes from. We know it doesn't cover all heritage, but that is the date that's used for automatic protection. I do want to highlight, and I know Elizabeth covered this in her slides, that there are several other measures available under the HCA to recognize and protect post-1846 sites and other sites of cultural value to different communities. With respect to your second question around the sort of labor market and archaeology, we're live to that. I'm actually an archaeologist by trade. That's what I did prior to coming into government. So I'm kind of keenly aware of that work. We're in conversations with the BC Association of Professional Archaeologists, and everybody is looking to work with universities on how we kind of garner more archaeologists from like kindergarten up into these professions to help support the demand. But the other piece is around the ARC regulation that we're talking about. We really want to ensure that we're considering transferability of people with these skill sets from other jurisdictions to be responsive. And again, I mentioned earlier the recognition that many nations have these skill sets, and again, recognizing those equivalencies as well to meet the demand.
Go back to Mayor O'Connor.
Thank you. I want to thank you for your words in response to my question. I guess my point with the first one, I use that as an example. It is the financial burden that's going to be put on, or that is put, and it's going to be put on communities like Lillooet's, like mine, like many others. We are entire heritage sites, the entire village. The work will have to be done. And so any ways that can be found, if there's no funding coming forward to support us, there's got to be ways as you go through. You said you haven't finalized the act yet. There's got to be ways you can find to help reduce those costs, because I think it could kill a community, the financial burden, to be honest. Thank you.
I don't know if there's a question or a comment, or we'll just take that under advisement. Or
Yeah, we'll take that under advisement, but we are very live to this issue. And if we are unable to find additional money to come in, we need to be as creative as we can with still respecting needing to protect these very important places. And so we are very live to this, and we are working hard to try to find some solutions in a really challenging fiscal environment. Yeah.
So when you have a situation we have in Lytton where we have a large area that's actually designated a heritage, or maybe under the new term, which would be the zone around it, when an area is deemed to have been checked, is there a method to say this area has been checked and it's now clear? I know on my own property, a large area was checked, but if I in the future decide that I want to put in a deck, I have to go and take another heritage permit to go back and dig in an area that's already been checked. And under the new legislation, when I sell my house, it's going to show up as having a site where there's been a find, but there's no way of saying this area has been checked. So is that going to be in the legislation, that when an area has been cleared by an archaeologist, that will be part of the registry, that we can say this area is now clear? And so in the case of a town, we can say these 4 lots are now clear, and you can work in other areas, because down the road, they're still going to be in that bubble.
Maybe, yeah, that touches on a few things. So I'm thinking, right now the archaeology branch has a variety of spatial layers. I know Elizabeth spoke to a few of them, and one of them has a study area layer. And so it is to reflect exactly what you've just described, which is where an archaeologist has been on a property, they've surveyed it, they've done some testing, and they've done a significant job, and there's no fines. Like, we will have access to that information. So when people are applying for a data request or accessing data to their property, we can tell if somebody has done a previous assessment on that property and give them that information.
Okay, thank you. Go over to this mic.
Just an update in reference to costs associated with this. For those, this is brand new, but at the Municipal Insurance Association AGM a few days ago, one of the special resolutions that we passed was related to for municipal properties anyways, related to costs associated with delays or ARC requirements. Right now to a limit of $25,000. They're starting off to test things out. I'm not a risk specialist, so maybe speak to them and find out what exactly it means, but it has been adopted by MIABC as a consideration for insurance claims for municipalities.
Okay, under advisement, go to the far mic, please.
Imut Kwaithquake and Kwannepe, Imut Namugis Ethnon, Richard Hardy. I'm a Area B Director with the Comox Valley Regional District. I'm also elected councillor with the Comox First Nation and one of the hereditary chiefs with the Sisitlik clan, which is involved with the Comox First Nation. Just a couple of comments, I guess. First and foremost, I know my time with the Comox Valley Regional District, I've always tried to encourage the local governments to work with Comox with regards to trying to figure out how we can work together when we start talking about archaeology. And I think the biggest thing with regards to trying to, again, maybe change our mindset, and it's one of the things I ran out and talked to the minister when he finished his presentation, was the fact that when we start looking at archaeology, it isn't just a First Nations archaeological site, in my opinion. When I look at the town of Comox, the city of Courtenay, it's their archaeological site as well. It's an archaeological site that belongs to people on Vancouver Island, the province of British Columbia in Canada. So I often feel this sense of it's us versus them when we start talking about the Heritage Act and the protection of archaeology. And I think every one of us in this room should be quite keen on, again, preserving our archaeological sites, because it's not just a First Nation site anymore. It belongs to everybody. And I think if we took that mindset, then maybe, relationships could be more enhanced. I see a lot of work with regards to what's been proposed here. I see a lot of pros, I see a lot of cons. I know, like I said, Comox Valley Regional District and Comox have been working hard with regards to their Comox and their cultural heritage investigation permit. And it might be something that the province might want to turn around and look at that model and see how it's working. One of the things I feel with local governments when you talk with them about the cultural heritage investigation permit that Comox has in place right now is, again, under the current legislation, the province, the local governments can't force a developer or force a property owner to turn around and seek out that cultural heritage investigation permit from the Indigenous nation. But I think a lot of resources, I think a lot of work with regards to, and I think one of my friends here earlier had made mention of the fact, go develop those relationships with the First Nations. We're not here to harbor development. But again, before we turn around and impact that archaeological site, let's get all the information we can about that site before it is desecrated. When we look at the Comox Valley, for example, over 90% of the archaeological sites in and around that area have been desecrated, they've been destroyed. So we have that small little component or these small little parcels now that it's really important that if they are going to get destroyed or impacted, that let's do as much homework, let's do all the science that we can on it before we turn around and develop or impact that site. So those are just my comments. Thanks.
Sure, please, yep.
Thank you for those comments. Maybe before you leave, it would be great if we could give you our contact information, because I'd love to hear more about that pro-con list.
Time for two more questions. I'll ask one, but we're waiting for somebody to come to the mic. We hear from the construction industry about concerns and delays. When construction is taking place on an archaeological site, one of the concerns that we've heard, as I heard it from my own contractor, is after you've dug the hole, it's all been checked, there's a reluctance to move that fill off-site for fear that the area that fill is placed will then get a heritage designation on it. And the same when fill is brought in, you've mentioned fill, but again, can be placed in an area, and then that area can be a circle drawn around it saying this is not native material. So in the construction, material and fill moves around, but it leaves the site, it comes into the site. And as long as you're checking what's going out and registering what's coming in, I think that's important from a construction standpoint. Just a comment. Let's go to the next.
I forgot to introduce myself before. Trina Isaacson, City of Pell River, Tla'amin Territory. One question is, do the proposed changes take into consideration potential technological advances. So even if an area has been reviewed, if new technologies develop in the future that would help explore that land even further and perhaps uncover things that were not covered before, is there room for that sort of flexibility? Thank you.
Can I ask a clarifying question? So, like, what are you meaning by like new technology? Are you talking about like ground penetrating radar?
Yeah,
or
so that
sensor
wasn't
LiDAR?
so if policy and legislation was enacted previously that spoke to digging in the ground,
Right.
and then other things became possible, how do we make room for other possible technological advances that we haven't yet incorporated? Thank you.
Okay, thank you for that.
And the last question goes to you.
Okay, thanks very much. Will Cole Hamilton, Chair of the Comox Valley Regional District. I wanted to follow up on my colleague, Director Hardy's question. Comox has developed a remarkable procedure of their own, the CHIP, the Cultural Heritage Investigation Permit, and I would like to see the province perhaps consider exploring the value of First Nations-driven permit processes as maybe a replacement or in place of a provincially mandated process. It seems to me that if one of the many concerns is to ensure that the artifacts of the Comox First Nation are not disturbed, I would think they're probably best placed to determine how that should be assessed. And I know in the case of in the particular cases on the projects we've been working on, Comox does have the flexibility and the resources to bring people in a much shorter time frame than the province. And it is perplexing in some ways to have the ability to gain a permit from the very people whose artifacts we're trying to be concerned about, and delayed while we wait for the province, with understandable capacity concerns, to actually be able to do the work themselves. So has there been contemplation of allowing First Nations to develop permitting programs to stand instead of the HCA in particular circumstances?
Hello. I actually got to hear a little bit about this yesterday from James, a little bit about this process and how well it's working. And so, yes, in one of the slides, I think we covered where we are trying to create the space for this. We would need to, there's some process around that right now that would look like a jurisdictional agreement that would need some pretty high level up to and including cabinet approval, but creating the space for that where it can work.
Thank you. And I just wanted to say, just to John Jack, I think you're right that building those relationships is key, and I like to think that we're doing that, and it makes the work, anyway, it's good work. Thank you.
And then I'll give you just a quick
just
final, because I think it'd be
quickly,
appropriate for you to close us out.
I guess my question is it fair to say that the amendments are to help the Crown's responsibility to Indigenous communities on behalf of the whole society by making sure that we do right by them through the criteria, but that doesn't preclude local governments being involved in finding those innovative solutions like CHIP. So can we think of it in terms of those agreements and ways to find ways to really meet the standards that the Crown has to uphold? Is that kind of the idea there?
You should maybe be up here on the panel.
Yeah.
Absolutely. And creating the space for collaboration. It just doesn't exist right now, right? The pathways and tools for that are not there.
Yeah, it's just the province is ultimately responsible for most of the consultation, Big C consultation, most reconciliation efforts. But local governments have innovative ideas. So it's finding those opportunities to create the value and the speed and the trust to actually avoid the concerns of that, construction times and all those things that we're talking about. So, like, for all the concerns we may have about this, we can be a part of the solution. You're not stuck in traffic, you're a part of traffic. You can be a part of the solution, right?
And I think those are great words to close. I want to thank everybody for being here today. A fascinating discussion. I want to thank our panelists. There was a lot of new information. I hope you took some information away. This is just the start of a conversation. UBCM is really pleased that the minister was able to come in today, that we're going to have a conversation with our executive. All of you are invited to be part of that conversation. And so, again, I want to thank you for attending today. And in appreciation of our speakers today, and with thanks for your contribution to UBCM has made a donation to the Threshold Housing Society. They are passionate about serving youth at risk, offering a nurturing and safe environment to support the varying needs of the youth and offer them a safe place to call home. So thank you very much, everybody.